Can you guys confirm that I'm actually live, that I'm streaming, that people can see me, that people can hear me? I know there's going to be a delay, but we want to make sure that I'm not broadcasting to nowhere. So Andres, Zeke, let me know when you start seeing something.
Yeah, now we can see something.
Yeah.
You're live.
Okay, I'm live. Well, great. It's good to be live, and it's been a little while since we did it last time around. As you know, some of you know, I've been traveling for 4 months. Now I'm back in Dubai. I was trying to avoid the Dubai summer heat, and now I am back. It's still hot, but it's bearable. And it was quite a trip. I can share a few stories from the trip, whether or not they're brand related. But as soon as you have a question, if you have a question, feel free to post in the comments, and I got my team that are going to bring the question up, and I'm going to stop entertaining you with my stories about the trip and switch to answering your questions. So the trip was 11 countries in 4 months. We left late May, and I think May 30th, and got back on October 3rd, if I'm not mistaken. And we did 11 countries, mostly Europe. Well, the big chunk of it was Europe, and then we also did Korea and Japan. And if you're following the channel, I've done quite a bit of shorts from each of those countries, and it's fascinating, really, what countries do and what brands do in each of those countries to make themselves stand out and become big and famous. And I think the last one, the one that I felt was really the best, probably the best illustration ever of the power of the brand, was Hello Kitty and their salt. So again, you can see it in the short that we've just published, I think like today or yesterday, something like that. And the whole idea is that you go to any Japanese supermarket, they sell salt, just regular table salt, and costs 88 yen. And 88 yen is roughly 60 cents, 55 cents, something like that. $1 is 150 yen. And then you go to Hello Kitty store, Sanrio, and Hello Kitty is just one of their trademarks, the biggest, probably. And you will see the exact same bottle of salt, even the same plastic bottle, except they just changed the wrapper around it with the words that say, hey, it's Hello Kitty salt, not just some regular salt. And instead of 88 cents, it's now 300. I'm sorry, not 88 yen. Now it's 300 yen, so $2. And it's unbelievable, really, that someone came up with that idea and someone's buying that, and it's the easiest way to increase the value of whatever product you're selling. In fact, Alex Hormozy, a guy who I've been following recently, I mean, who hasn't? If you're trying to build a business, if you're trying to grow your business, I'm pretty sure you've heard of Alex, and I'm pretty sure you've followed some of his videos and maybe gotten his books and free courses. I know I have, and they've been amazing. So he has one video and 17 lessons or something like that. And the very last lesson in that video, he talks about the power of the brand, and he talks about Warren Buffett talking about the power of a brand. And the whole idea that he brings up is that the brand, the value of the brand is really by how much more you can sell a generic product when it carries the brand. So, or if it carries the brand, right? So you got a white shirt with nothing, and you got a white shirt with Nike swoosh, right? The white shirt with nothing you can buy for $1. The white shirt with Nike swoosh that says just do it, you're gonna pay a lot more than $1, right? So the difference, the margin, is really about the power of the brand, the value of the brand. So that's why Warren Buffett prefers to invest in businesses that have well-established brands, and so does Alex Hormozi. And really, the only way you can establish a brand is when you own it. Is if you don't own the brand, like there's nothing to establish. It's not even a brand. It's not only that you don't own the brand. It's just nobody has. It's not a brand. It's just some words, some pictures that you like, and that you hope your customers are gonna like, and that they're gonna somehow think that that's your brand. But it's really not a brand until you've trademarked it, until you own it, until it's yours, and until nobody can take it away from you. So going back to Alex and Warren Buffett. I found that video absolutely fascinating because it's so succinctly explains how having a strong brand can help you charge more for whatever it is that you're selling, right? Whether it's your products, whether it's your services. If it's a no-name product, then it's not going to be worth very much. And if it's a branded product, then you can add more. And more and more and more and more, and that's why you get iPhones sold for so much more than any other phone out there. That's why you got, some of the luxury cars, because they're not that much better than Kias. Like a Rolls-Royce and a Kia, if you compare the two. Well, obviously, Rolls-Royce is nicer, it's more luxurious, better materials, but it's not that many times better, right? And the reason people pay more is the brand. And again, really well illustrated with that story of Hello Kitty salt. So again, if you haven't watched that video, once this live is over, you're welcome to watch that. Okay, so we got our first question, great. Question from Hometown Fitness: how much does it cost to trademark your brand name for a product? Okay, so just trying to decide how to answer your question, because there's really two ways to answer your question. One way is to give you a lecture on comparison between Trademark Factory and everyone else, and the other way is just to tell you what's our most popular package that everyone goes with. Let me think about this. You know what? I do need to give you some context because otherwise it's hard. So I'm going to start with just giving you the number that we charge. That's our most popular package, and then give you a little bit of context as to why this is the best offer on the market today. So with our most popular package, which is all-inclusive, one brand in one country will cost you $2,600, $2,595, plus the government fees. And that includes everything. That covers the comprehensive trademark search, that covers an attorney drafting, filing your application, being an attorney of record from start to finish, responding to unlimited number of office actions, dealing with the whole thing from start to finish, evidence of use, all of it. And it comes with two major 100% guarantees. The first one is during the search stage, if we see that there's a problem with your brand name, will tell you, hey, we got a problem. You can't trademark that. Somebody already owns it, or it's too generic, or it's too descriptive, or it doesn't function as a trademark, or it's deceptive, or this or that, right? If we see any concerns, we tell you, and if you don't want to try something else, maybe tweak it, or change it to something completely different, you can just get all your money back. The second 100% money back guarantee is if we tell you it's going to go through, but for whatever reason it doesn't, then you also get all your money back. So we're the only firm that does this. And here's the context that I promised you. So I'm sure if you do your, in a simple Google search, you'll see tons of websites out there that promise to help you with your trademarks for a lot less than $2,600. The problem is what they do is just a small fraction of what you get with Trademark Factory. You get just them filing your trademark based on whatever words that you give them, whatever information that you give them, right? It's not filed by an attorney. It's not doesn't have an attorney of record. If you have an office action to deal with, if the trademarks office rejects your application, there's nobody going to help you with that. You're going to have to find an attorney to do this for you, and then you're paying them by the hour. So all of that, and no guarantees, right? So that's why you really want to compare apples to apples and not apples to oranges. And the other possibility is when you go with traditional law firm, they do things right most of the time, except that their model, their pricing model is based on, hey, let's file your trademark and then we're going to charge you by the hour to fix the application that we just filed for you when there is a refusal. And there's refusal in 68 to 81% of the cases, depending on who files your trademark. So speaking of, Trademark Factory has a 99.3% rate of success, and that's there is a reason behind it, because we get your trademarks done right. So I hope that answers your question. I don't want to do this, turn this too much into promotion of Trademark Factory, because you can go to our website. The prices are all there. They explain all the packages and all that stuff. So do we have more questions? I think we do have more questions, if we can just turn them on. Yes. Okay. So CFN came from nothing asks the question. I can see the question. Can you guys move the okay, hang on. There we go. All right. So do we have a timeline to send companies a cease and desist letter to stop them from doing business, I'm assuming, under a brand that you own? So there's no specific timing. So it's not that if you don't do it in 269 days, then you're out of luck. But the rule is that if you allow somebody else to use your brand without your permission, with impunity, openly for long enough time that it would be reasonable for them and the public to think that you don't really care about that brand, then you can run into problems, right? So typically the rule of thumb is when you find out that someone is ripping you off, someone's copying your brand, somebody's doing something that they shouldn't be doing, that's when you want to reach out to your law firm and ask them, hey, do we want to do something about it? Do we want to go after them? Do we want to send them a demand letter? And usually you want to do it, again, just within reason, right? Maybe so it's not about the timing between when they started infringing and you sending them a letter. It's between you finding out that they're infringing and then you sending them a letter. So this Second, this latter timeline should be reasonable, right? It doesn't matter how long they've been ripping you off. If you find out about it and then react promptly, that's good enough, right? But you shouldn't be sitting on this knowledge that, hey, they're ripping me off, I know, but I'm going to wait for them to make $1 billion and then I'm going to sue them. If you're caught doing that, you may find yourself in trouble because they'll be able to argue that you gave them what's called an implied license, right? It's called the doctrine of estoppel. But again, I don't want to turn this into a legal lecture. So usually, you find out about it, you get back to them within a month or two, that should be fine, unless it's something very time sensitive. When it's like something's happening right now continuously, right? At that point, you may want to notify them right away. I remember back when I was still practicing law in Russia, was with the biggest law firm, and we had a situation with Apple, who was our client, and somebody posted the source code for macOS, right? Something that became Hackintosh later. And they posted it on the website that was a news website in Russia, pretty big one. And so client is freaking out, and I got the file on my desk in that morning. And I'm looking at it and I realized that if we simply go traditional route, which is, a lawyer puts together a long cease and desist letter, and then we take it to the partners. The partner reviews this. Then we send it as a registered mail, and then we wait for them to respond. Then by the time all of this happens, it's too late, right? The whole thing is out there. So I remember, and I'm actually very proud of that. It was one of my favorite unconventional ways of dealing with a situation on behalf of a client. I found the contact of that operator of that website on some messenger, ICQ back in the day, it was called. And so I messaged them there and basically saying, hey guys, we saw this, I represent Apple, take it down because you're too good of a website to be involved in garbage like this. And literally the whole thing took me probably like 15 minutes, and they took it down right away. And so I had an interesting conversation with the partners of the law firm, because on the one hand, the client was ecstatic. We got everything done very quickly and very efficiently. But on the other hand, right, they didn't generate just enough billable hours, I guess. But the team that I used to work for, the company, was very, very good. They're all understanding. They had a few giggles about it, and so just going back to, just do what you can as quickly as you can, and you'll be good. All right. Do we have more questions? Okay. What is that? So let's move this. Hey guys, you should move this so that it's actually sitting in the right place of the screen. Okay. Saying it back to my team. All right. So question from Diva CEOs. I own Diva CEO, so it's registered and a party is using Diva CEO and CEO Diva. Is that an infringement? Most probably yes. So plural or singular is exactly the same thing when it comes to trademarks, and that's the beauty with trademarks, and a complication that a lot of entrepreneurs don't understand is that trademarks don't only protect you against literal copying when it's exactly the same thing. It also protects you against lookalikes, sound-alikes, mean-alikes, added suffixes, added prefixes, added words, removed words, misspellings, even translations in certain cases. And it's not like domain name when all you should do is just add a 1 at the end and you can own the domain name, right? Or add a misspelling, remove a vowel, and hey, it's your domain. That's not how it works with trademarks. But with trademarks, just the fact that they're infringing means nothing until you've let them know that you saw this and that you're not happy and that you're going to take action. And if they have any sense of self-preservation, if they're making any money on this brand, them receiving a letter from a law firm that says, hey, we represent Diva CEOs, they own a registered trademark on Diva CEOs that covers these and these goods and services, and it has come to our attention that you have been using confusingly similar designation Diva CEO and CEO Diva to do this, and this. This falls squarely under the definition of trademark infringement, and therefore we hereby demand that you immediately remove any instances where you're using this brand, maybe pay my client a certain amount of money, provide accounting of profits. Lawyers know how to write that kind of stuff, and probably you shouldn't expect them to pay you any money, but it's pretty likely that they will take it down. Again, if they're in North America, if it's not some website out of third world country that you really would have big difficulty getting a hold of them, if they have some business that actually makes money, more than likely them seeing that letter, seeing a copy of your trademark registration certificate should be enough for them to say, you know what, we're just going to pretend we never received that letter, but all mentioning of Diva CEO and CEO Diva will be gone. That's what usually happens, and that's one of the big benefits of getting your brand registered as a trademark, because if you don't and you send that letter, first thing those infringers are going to do is they're going to check. Did you bother to trademark your brand? And if the answer is no, then the lawyers would typically tell them, hey, they didn't bother to spend a little bit of money to file a trademark. The likelihood that they're going to spend significantly more money to go after you in court is much, much, much lower. So they'll say, you know what, let's see. Wait and see. If they do file a lawsuit, then we'll deal with that, but the likelihood of that is pretty low, right? And when they do see that you got a registered trademark, so again, law is all about risk management, right? If it's all about trying to figure out how bad is the risk that something bad is going to happen to you, and the second factor is how bad can it actually get, right? And a registered trademark tells them the likelihood of something bad happening is pretty high, and forgot the word. And the extent of how bad it can get could also be pretty high. So hope that answers your question. Okay, so another question from Hometown Fitness. Do we take care of getting products listed on Amazon and Walmart? We don't, but once you file your trademark, you can then go to Amazon brand registry and say, hey, we filed a trademark application, here's the number, and then Amazon is going to send us, our attorney, a code that we can then give you, and then you can provide it to Amazon. I don't know if Walmart has their own brand registry. I've never heard of it, but Amazon, yes they do, and they've recently made changes that not before. originally, you should have waited until your trademark would have gotten registered. Now, because the process takes so long, it's about 1.5 years in the US, now you can apply for Amazon brand registry after you've just filed your trademark application. Because and again, they're going to review it. They're going to see, hey, there's an attorney of record, and they're going to enlist your brand on their registry. So we help you in the sense that we coordinate the communication, but we are not actually posting on your behalf, because that's something that only Amazon account owner can initiate on their end, and on our end, again, gets to the attorney, and we take that information back to you. All right. Next question from Leon Basin. I am currently waiting for our trademark to get approved in Canada using Trademark Factory. Thank you. In the meantime, we want to trademark our brand in other countries, China, Europe, USA. Can we do it? Yes, and we can certainly help. I don't have in front of me the date when we filed your trademark in Canada. If it's within 6 month window, we can actually use what's called conventional priority, which means that we can file your trademarks in other countries now and backdate them to the date of your first trademark in Canada. And if it's outside 6 months, then conventional priority won't apply. But yes, we can still help you with that. We filed a ton of trademarks with in US, tons of trademarks in Europe, tons of trademarks in China. So okay, so I got my team helping me with this. Yeah, so we filed it in March of 2022. So yeah, way outside of the 6 months window. But yeah, Canada takes probably the longest of them all. Europe and China will be faster, and US is going to be somewhere in the middle. So by all means, we can help. Actually, I can get someone to reach out to you and see if we can get the process started. Zeke, please get back to Leon, and we'll take it from there. Okay, so do we have more questions? Okay, so question from Make It Happen. I remember this brand. It's relatively recent. So does Trademark Factory pursue cases of infringement? No. What about patent infringement? No. So we're not a law firm. We're not a litigation firm. We're not a patent firm. All we do is we help brand owners trademark their brands with a guaranteed result for a guaranteed budget. And that means that we find providers in the jurisdictions that where we file. So for example, just, as I mentioned, China and Europe, we're not there, right? Like, we can't have every single license, and we don't want to, because really what makes us special, what makes us different, what makes us better than even the providers that we use is because we provide much better client experience, and we provide the guarantees on top of that. So we take all the risks, and we basically you get the best attorneys out there working on your file without you having to deal with all the attorney bullshit that is typically associated with attorneys. So we do all that on your behalf, and you get the results that you care about. All right, what else we got? We got a question from Ann Russo. Can you only trademark a brand? Can you trademark a slogan? Well, a slogan is a brand. So, but let me take a step back and actually go through this, because I think it's a good it's a good opportunity to cover this. So there's generally 5 things that you can trademark. One is the brand name, the company name, right? Or if you're an individual, your personal name or pseudonym or nickname, right? If you're a music band name. So the name under which you're known. And second one is name of your product. So if you have products, physical products, and they have names like iPhone, right? So there's no company iPhone Inc., right? So Apple. So the example of the first one is Apple, right? Apple, McDonald's, right? Starbucks. That's a brand that's important for them, obviously, to own, but that refers to the actual brand. And then the second one is when you have names of products. So iPhone, Big Mac, Frappuccino, and you trademark that. Your third option is when you have names of services. When you have specific services that have names, or it could be names of courses. If you're like in infobiz situation, you come up with a course, with a program, you give it a name, you trademark that, and I don't know, iTunes is a good example, or Mac Cafe, right? So all of those are trademarks. The fourth option is logo, right? If you have a visual representation of your brand, that's another thing to consider trademarking. And lastly, it's taglines or slogans. Just do it. I'm loving it. All of those are extremely valuable. Well, especially I would say, just do it. It's done Nike a lot of money. Them being able to own it and stop everyone else from using that in connection with apparel. So slogans, absolutely, you can trademark. If you see that, because look, think about this. A slogan really is your marketing piece. If you can get a monopoly on a marketing piece that works for you, it makes perfect sense that you do. So if you see that people are reacting well, if you see that you want to be known for something, like for example, we're trademarking guaranteed result for a guaranteed budget. We've trademarked if it's remarkable, it's trademarkable. We've trademarked if it's worth protecting, if it's worth promoting, it's worth protecting, right? These are all registered trademarks of Trademark Factory, and we use them here and there because we feel that these phrases allow us to convey what Trademark Factory is all about, what the value of trademarks is all about, and we want to make sure that we own it and that we can stop others from using that. So yes, absolutely, you can trademark a slogan. You're more than welcome to get on a call with one of our advisors, and they'll give you more details about your specific situation. Okay, so a follow-up from the US CEOs. Thanks for the answer. Any laws that prevent suing the infringing party if they're under insolvency or bankruptcy law? Understand they can't sue on their end. This is beyond my pay grade. Look, I'm not a litigator. Whether there are rules the special rules about defendants in bankruptcy, I don't know. There might be, there might not be. Again, I don't want to say something that I'm not sure about. This would be a question you would raise with your litigation firm, and I strongly discourage you from doing it on your own. There's so much stuff that can go wrong, and litigation is is not about who's right and who's wrong. As much as I'd like to say that, the legal system is about justice and about fairness, no, it's about which lawyer knows the process better, which lawyer can create a better story and convey a better story to the judge. I've seen countless examples of brand owners who were in their right, who would try to be their own lawyers. They'd come to court. They say, hey, this is my brand, blah 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 blah, and they got nothing. They got kicked out. In fact, there's this process called cancellation proceedings, which is slightly different, but I think it's a good example to mention nonetheless at this point. So cancellation proceeding is when somebody registered a trademark, and so they have a registered trademark, but for whatever reason, someone else wants that brand, and that first trademark is in their way. So the new owner, the new applicant, can initiate proceedings called cancellation proceedings when they request the trademarks office to request the owner of the original registration to prove that they're still using their trademark, that they're still out there selling their stuff, that they're still out there using their brand as registered. And if they fail to provide evidence that's satisfactory to the trademarks office will cancel that registration as if it never was registered, and the new applicant can get their brand trademarked. So we had a couple of situations like this when we had clients who asked us to file a trademark. Everything looked like the other brand owner wasn't there, otherwise we wouldn't have initiated cancellation proceedings. That's an important ethical moment for me. But one time, and I remember it was really painful for me to see. So we filed that request for cancellation, fully assuming that the other side is not going to respond because it didn't look like they were around anymore. Lo and behold, we get a response from the owner of that other trademark that says, hey, actually I'm still around, I'm still using my brand, I'm still selling products. And we go back to our client and say, hey, look, it doesn't look like we can succeed with this, but let's see what happens. And so the trademarks office gets back to the owner and says, you need to provide evidence, not just say, hey, we're still around. You got to provide evidence. And so what she did was just send a bunch of photographs in an envelope, and it wasn't done in a way that was required by law. And so the trademarks office looked at that and said, as much as we'd like to see that the registrant has fulfilled her obligations to provide evidence of use, she didn't, and they canceled her mark. So she was 100% right. Her mark should not have been canceled. But because she tried to be her own lawyer, she lost. And so our client was happy. We were kind of torn about this because, again, on the one hand, we're happy that we were able to help the client. On the other hand, we knew that really the opposite of justice was served. But to me, it also served as a good lesson for people to not be their own attorneys, because it looks self-evident, it looks common sense, like, hey, I'm in business, here's the photograph, the trademarks office should respect our rights. No, you gotta do things exactly the way that they're expecting, and if you don't, they're not going to be merciful. So I hope that answers your question. Just go to a law firm, ask them, and they're going to tell you whether or not you can still sue. Okay, we got a question from Bull. Is it okay to trademark logo after doing the name? Yes. Another great question. We got a ton of great questions today. So in fact, a lot of people ask the question the other way around, like, hey, you know what? I'm not ready to do a trademark because I don't have a logo yet. And I tell them this makes zero sense because first thing you want to do is find out if the name is even trademarkable, because if the name is not trademarkable, why would you spend any money designing the logo, putting the logo out there, right? You wanna first find out that the name is trademarkable, then do the logo. So if you have both, and we have clients obviously who come to us with both a name and logo at the same time, we can help them with both. If you only have a name and there's really no reason for you to delay filing your name until you have the logo. File the name first, make sure that that's in the system, then go back, get the design around your logo, and go from there. But again, this only works with Trademark Factory because we always start with a comprehensive trademark search, right? We will never file your trademark unless we've done a comprehensive search and we see what's out there. I don't want you to waste your time and money filing trademarks that have no chance of going through. It makes zero sense. I don't want to have a conversation with you 2 years after you became our client saying, too bad, so sad, your brand is not registered because there was this other trademark and we didn't know. So we always start with a search. And this approach is really the secret behind our 99.3% rate of success, which is way higher than anyone else in the market. On average, like it's the statistic on aggregate, it's I think 50, I always forget the exact number. I think, well, definitely less than 52%. It's either 51.8 or 40, whatever. Less than 52% of all trademark applications that get filed make it to approval. So roughly half of applications that are filed die, right? With us, it's 99.3 that end up at the finish line and only 0.7 that don't. So there's got to be something we're doing right. So just going back to the question, find out that your name is available. Like if you have a logo already, great. You can start with them both. We'll do a search. If we see that the name is not available, then you can go back and tweak them both. And if the name is available and the logo is available, we'll file them. Or if you only have one, start with the name and then add the logo. This is really something that is going to be part of your conversation with a strategy advisor, right? When you go to trademarkfactory.com, you request a call with a strategy advisor. That's the type of conversations you should expect to get, because their role is not just to take your credit card number, right? Their role is not to convince you that, hey, Trademark Factory is the best thing since sliced bread. You know this already. Otherwise, why would you be booking that call? But in all seriousness, their role is to help you prioritize. What do you start with first? Is it the name? Is it the logo? Is it the tagline? Is it in the US? Is this in Canada? Is this in Paraguay? Like, they need to understand your situation, and they can give you good advice as to how to start with. So that's my suggestion to you, right? If you're not sure what you're trademarking, get on that call with a strategy advisor, and they'll be able to help. All right. So I know that my team in the background were trying to switch to new question, and I kept rambling, but I'm done. Let's switch to the next question. Give me something else to answer. All right. All right. Question from Foodie Village. I have a project that involves blockchain and Web3 protocols. Some call it NFT 2.0. It's a system that will help manage digital assets. How can that be trademarked and or patented? Okay. That's a great question. Love it. First of all, I'm not going to answer the part about patenting. I don't we don't do patents. I understand how patents work, but this is way outside of my comfort zone to provide actual advice. So let's go to trademarks. And trademarks really don't care about how good, innovative, or brilliant your product is. And this is a mistake we see a lot of times with self-filing applicants, because they're trying to use their trademark application as a marketing piece. They're trying to convince the trademark examiner, hey, we've got the best services out there. Nobody has anything like this. Our services are so amazing. We do this and we do this and we do this, and it always gets a refusal when worded that way, because again, trademarks office, they don't give a damn about whether you're better than your competitors. All they care about is, what is this actually, right? Like, what is it, right? They don't care whether it's blockchain, Web3, Web4, Web49. That really doesn't matter to them. They only care about what it is, what it does to the public, right? Is it accounting services? Is this a website featuring online information about I don't know, celebrities? Is this legal services? They want to put you in the box. They want to put you in the box that will allow them to say they do this, right? And they don't care, again, how you do it. They don't care how well you do it. And so when you file your trademark application, try to minimize the amount of information that you give them, because the more you say, the narrower your application becomes. So if you say it's a website that features blockchain, Web3 protocols, that does this, and this, it sort of limits you, because what if somebody else has a similar name that doesn't have blockchain and Web3 protocols, right? You want to protect the name, you want to protect the logo, you want to protect the tagline. And so all you want to do is just say, an online platform that does this. So, Foodie Village, I don't know what it is. Whether you, I'm just going to guess, right? And I'm probably going to be wrong. But for example's sake, so let's say you let people find some gourmet meals in restaurants within 10 miles from where the person's searching. I don't know, just like, where is the best pupusas, right? Near me, right? And all you have to do is just say, hey, it's a online website online service for finding restaurants, right? The less you tell them, the broader the protection. So I hope that answers that question. Let's move to the next one. Question from DJ Snyder. Are people able to troll and take advantage of brands without a trademark? For example, a well-known brand has not officially filed a trademark and you decide to file for it. How would it play out? It happens all the time. Well, let me rephrase that. It rarely happens with well-known brands, because well-known brands are smart enough to take care of trademarking early on. It does happen with up-and-coming brands from novice entrepreneurs who haven't done it before, who haven't been burned before. And the way it usually plays out, somebody else files a trademark, and And then they send the cease and desist letter to the actual brand owner and saying, hey, you know what? We've got a trademark on this, and we'd like you to stop using your brand because it infringes on our trademark, and we want you to pay us some money. And the owner of the brand goes nuts, and they say, WTF, like, that's my brand. Who the hell are you? And they go see their lawyers, and their lawyers are going to say, well, you can fight this. It's going to take a couple of years, and it's probably going to cost you, I don't know, maybe $80,000 to $140,000 in the first instance court. And the chance of you winning is roughly, I'm just making this up right now, of course, roughly 60%, right, or 65%, just to make you want to do it. And they're going to listen to that. They're going to freak out even more because they don't have $140,000. They don't have 2 years of fighting this. They don't have any desire to get themselves involved in a legal process that can result in a negative result for them in 40% of the, or 35% of the cases. And so what they'll do is they'll say, hey, can we just buy it off of them? And that's, of course, really the reason the other company started the whole thing. And they come up with a number that's less than 140K, and it looks like a compromise that everyone's happy with, but it's really stupid way to lose your money, because all you had to do, so again, the first question on the call today was, how much do we charge for trademarks, right? $2,600. So compare that, just you pay $2,600, it's your brand, it's your trademark, to you having to deal with lawyers and pay them God knows how much with uncertain results, right? That's why it makes no sense. But so another example I'm going to give you is a true story. Again, when I was still working in a law firm in Russia back in early 2000s, we had a client, Starbucks. I had a video about this, and somebody in Russia got a trademark for Starbucks long before Starbucks decided to come to Russia. And at some point, they realized, hey, I think they thought it's time to come to Russia. And they realized that somebody else had already trademarked it. And so they hired our law firm to fight this, fight this registration. Took them 7 years, I think, and well into six figures in the fees that they paid the law firm. So eventually they won, but it wasn't just about the money that they paid the law firm. It was more about how much money they didn't make selling coffee for 7 years. And that was a much bigger problem for them. So, does it happen with big brands? Occasionally, yes. Usually on international level, because it's very hard to come up with a brand that you're going to own everywhere. Usually you don't have the money when you're starting out. By the time you grow, it's a race, right? It's a race of you making so much money quickly so that you go and trademark your brand everywhere before trolls in those countries go after it as well. And again, it's a cost of doing business globally, unfortunately. So that's my answer. Hey, I've got another question from, you know what? let me get a drink because I'm losing my voice here. Okay, so question from Stuart Brady. My company is waiting for our Canadian trademark to get approved, but meanwhile, a brand in China is trying to trademark both my company name and my company logo. What should we do? It's tough because really there isn't very much that you can do. Unless again you're within 6 months from your Canadian filing date. If you are, then you should run to the Chinese trademarks office, file your trademarks there, and claim conventional priority. If you're outside the 6-month window, then there's nothing you can do really, except just buy it off of them, which is probably what they're trademarking a brand for in the first place anyway. So I wish I had a better answer for you. Unless you're so well known that everybody knows your brand everywhere, including China, there's very little you can do outside of just paying them off. I'm sorry. Question from MX Writer. I have a question about niches. I'm looking to include truck parts under my brand in the future and wondered if that would hurt me since I did not list automotive when I filed. So you cannot add goods and services to your existing application. So if you file a trademark and it says, I don't know, apparel, and then 2 months later you realize, you know what, I will also be selling refrigerators under that brand, or I will be selling cars, or I'll be selling computer parts, or whatever. You cannot go back and ask the trademarks office to add stuff to your existing application. You have to file a new one. And that's how a lot of big brands like Apple, Amazon end up owning dozens of trademarks that look identical, like the same brand, but they're all filed for different goods and services. So, they come up with new ways to use the same brand, they file a new application. They come up with something else later, they file another application. And it's unfortunately, again, part of doing business, part of growing, when you realize that you pivot and you're doing something else. And look, here's something that we say to all of our clients. If your business, if your brand fails, right? If nobody wants to buy your stuff, if nobody cares, if nobody sees any value in the products and services that you're trying to sell to the world under this brand, then $1 that you spend on trademarking is $1 too much, right? It's just the cost of doing business. Same thing as the money that you will have wasted on your ads, money that you will have wasted on your team, money that you will have wasted on your office, money that you will have wasted on the website, like on everything, single thing that you do for a business that fails is money that's gone, right? But if your business, your brand ends up becoming success that you're hoping for, then your investment in trademarking the brand will probably be your investment with the highest ROI ever, because the value of your brand will only continue growing. Some of the examples that I always, Coca-Cola, right, filed their first trademark in 1892, year when they were selling 9 drinks a day. Somebody said, you know what, it could be a lemonade stand with a dream, but let's go and trademark this brand. And back in the day, you couldn't just go online and fill out the form and get everything filed, right? They had to go to lawyers. They had to get it done. I don't know how much they paid, of course, but I'm pretty sure that people who saw that they went out there and paid somebody to trademark their brand, their logo with this cute font, I'm sure there were a lot of naysayers who said, you guys are nuts. who's going to steal this from you? You have a drink that nobody wants to buy, and you're spending so much money on trademarks. And today their brand is worth over $70 billion, right? Just the brand alone, not the factories, not the people, not the distribution chain, just the brand. So to me, I don't know how much they paid. That's, whatever they paid their lawyers to trademark their brand back in 1892, I'd say it's pretty good return on investment today. So I hope that answers the question. Question from PlayStation 4. Okay. How much will it cost to trademark a nonprofit organization? Same thing, right? It doesn't matter whether you're a nonprofit, for-profit. Our fees are exactly the same, so it's $2,600 for your trademark. And for nonprofits, trademarks actually are not any less important. They might be even more important because you are dealing with trust on a much higher level than for-profit organizations, because with for-profit, right, you sell stuff, you get money in return, you provide value in return, and you got reviews, you got this and that. With nonprofits, you have to convince people that they're dealing with the certain entity that has certain reputation. Now imagine what's this? Hang on. Zeke, you can help me, maybe. What's the name of that nonprofit that collects money for children, like Last Wish or something? What's it called?
Maybe UNICEF?
No, not UNICEF. I had a great story, and I can't remember the brand. I guess yeah, Make-A-Wish Foundation. Yes, thank you. So imagine, so you're Make-A-Wish Foundation. You're going out there with all those stories, and you're trying to get people to donate. But imagine if there's somebody else saying, "I'm also Make-A-Wish Foundation. Give money to me." Right? And that would be a massive problem. And that could happen if they didn't own the trademark. The only reason that people are confident that they're sending money to the right one is because it's trademarked. So, Andreas, can you mute yourself, please? Thank you. Okay. Next question. All right, so CFN came from nothing. How do we go by getting an attorney of record for trademarks? Since my trademark is in the first stage without an attorney of record, can we pay your company to take over plus get an attorney through your company? Maybe. So we prefer, of course, to get the process done from start to finish, right? Because that allows us to make sure that we do a proper search, that the application is done properly, that, again, we don't want to attach our name to something that's done poorly. Sometimes we help brand owners fix applications. It's really on a case-by-case basis. So I'm trying to figure this out. Yeah, so you know what? Why don't you send an email to tm@trademarkfactory.com, because we don't want to make it public record. So this is our main email. So tm@trademarkfactory.com. TM stands for trademark. tm@trademarkfactory.com, and say, hey, I was the one on the live. Here's my application number. And my legal team, they're going to have a look at your application, see how how problematic it is, and based on that, we'll get back to you and let you know if we will be able, or if we'd be willing to take over. Okay, fair enough? So let's do that. Next question from Andy Power, from Cindy. Okay. Can I trademark something like a stove? Absolutely. But again, you will not be trademarking the stove. You'll be trademarking the name of the stove, or you'll be trademarking the logo that identifies the stove, or you'll be trademarking the tagline that identifies the stove, but not the actual product itself. Just because you get a trademark on the name of the stove doesn't mean that others will suddenly no longer be able to make and sell their own stoves as long as they have a different name. So every single product under the sun really has been split into 45 categories. They call them classes. Classes of goods and services. There are 34 classes of physical products and 11 classes of services, right? So stoves would fall under, I don't know, one of the first 34 classes. I don't remember what number it would be. Appliances, right? And you just file your trademark. You say that's the name, that's the logo, that's the tagline, and when they ask you to provide the list of goods and services for which you're trademarking, you're just going to say stoves, class X. But again, this question shows to me that you would benefit from having a conversation with one of our strategy advisors, because that's really, I'm going to take off my know-it-all trademark expert hat off and put the hat on of me, entrepreneur. This, to me, is our biggest challenge, because what we realized is that most people who fill out our forms on the website, they grossly overestimate how well they understand the trademarking process, and it's really tough, because it's very hard to market to people who think they know it, who are sure that they don't want to hear some of the things you need to tell them, and then you realize they have no idea what they're talking about. And Cindy, I'm not saying that you have no idea what you're talking about. This is a kind of general observation, because we used to have a landing page. I remember testing it, and we were blown away by results. So what we tested was, so there's a landing page that explains what we do, that explains why Trademark Factory is the best offer in the market, and we decided to test something very different. There's a pop-up that asks you for the name, and then it says, there's a question that says, how certain are you that you know what you want to trademark and where, right? And something like that, maybe not verbatim. And two options to the question. First option is, I know exactly what I want to trademark, for which goods and services I want to trademark, in which countries, like I know everything. And the second option was, I would benefit from watching a short 6-minute video that explains this in detail. And then there was a second screen that would say, how well do you understand the Trademark Factory offer and how it differs from everyone else in the trademarking industry? And similar two answers. One say, I know exactly what Trademark Factory offers. I understand the guarantee, I understand the trademark story, like I know all of it. And the second option was, I'd rather watch another video that explains this in detail. And so we ran this landing page for a couple of weeks, and we got hundreds of requests, and we're listening to some of the conversations that happened between the strategy advisors and the people who fill out those forms, and the vast majority of them like answered that they know how trademarks work, they know exactly what they want, they know the Trademark Factory offer, they get on a call, and so the strategy advisor says, well, you said that you know this, this, and this, so what do you want to trademark, and why did you decide to go with Trademark Factory? And they're like, trademark what? Trademark who? Like they had no idea. And when we saw that, it was really eye-opening in the sense that people feel that trademarks are really simple. It's like you come up with something, you fill out a small, you do a little bit of research, you fill out some form, and you're done, like domain name. Anything but, right? It's very, very, very different. There's a lot of subtleties and a lot of complexities there. So, Cindy, going back to you, it's always a good idea to talk to somebody who filed lots of trademarks, right? Trademark Factory has done this for over 3,000 people, 3,000 brands, 3,000 companies, and we kind of know what goes in a trademark application, when it's a good time to file a trademark application, when it's not. And the other thing here is that you also want to talk to somebody who gives a damn. And that's another big part of what I think makes Trademark Factory different, in that, to me, filing one extra trademark is not going to change my life. It's not going to change the life of, my team. But it can change the life of the person who came up with that brand, who woke up one day and said, I'm going to start a business under this brand. I'm going to put this name onto my products. And them owning that brand could change their life. So to me, it's a lot more important to help those who care. And that's why me and the entire team that we have here, it's over 30 people now, really the big criteria of how we are is that we actually give a damn about you, your business, your brand, and we want to make sure that if you are investing your time and money in building a brand, that you're doing it for a brand that you own. So hope that answers the question. Question from S. Okay, hang on, let me have a drink. All right. Question from S. Zayman. Hang on, let me move this. Trademark Factory filed the USA trademark in March. Our products are manufactured in China. Now we want to file trademarks in other countries and China. Should we wait till we get the approval in the US? No. So China, you got to file like today. So if it's March, then the 6 months would be over in September. So we're probably out of the 6-month window. I would say China is absolute necessity, ASAP. The reason being, if somebody else files your trademark in China and you make your stuff in China, if somebody else trademarks it, they can prohibit you from exporting your own products outside of China to the US. So I would say China should be your number one priority ASAP. And other countries, also important. I wouldn't necessarily wait to get the approval in the US. Do a search, have us do the search, and let you know if the brand is doable, right? Again, I don't have your trademark search report in front of me. I don't know if we told you, how trademarkable your brand is. I'm assuming we gave you 100% on that, but Zeke, again, here's another one for you to follow up with. So I'm going to ask Ezekiel to give you a call. I don't know, today, tomorrow, and see how we can help you get started on this. Okay. Okay, so it's see, it's not even in the question. There's not a question mark there, so I don't know how to answer that. But thank you, Andrew. Thank you. Really appreciate the kind feedback. It made my day. Here's a question from Johnny Evans Jr. Can I trademark LOL if my words are not laugh out loud? For example, hang on, left out leaking. Okay, so funny enough, this actually brings back some sentimental memories, because I remember that when I was taking my first trademark law classes back in God knows how long ago, that was also my question. I also was all about abbreviations and whether you can do this or not. And so the answer is it depends. It depends on whether somebody else has trademarked the abbreviation. And if somebody else is known under the abbreviation. If someone owns LOL for your specific products and services, then you're SOL, right? You're shit out of luck. It won't go through. But if they haven't, then you can. And what Trademarks Office doesn't do is they don't compare long versions versus another long version if the abbreviations would have been the same. So for example, if one company owns laugh out loud, not LOL, but laugh out loud, and you want to be left out leaking, to a Trademarks Office, it's two different things. And if they did LOL and you did left out leaking, you could probably also get away with that, unless their LOL was so well known that the reasonable consumer would think that it's the same thing. And the only situation when this could be a problem is if you're prominently putting LOL in your brand, or if you're doing LOL dash left out leaking. So all of this is a very theoretical question, as much fun as it is to dissect it now. That's what comprehensive trademark searches are for, right? That's why you never want to rely on you doing your own search by going to either the USPTO's website running a search, or some of those free websites that allow you to do a free trademark search, because you're going to run a search, you're going to get some answers, you're going to have no idea how to interpret them. And there's really a lot that goes into it, and about likelihood and risks, and again, just get someone to do it for you. And if you go with Trademark Factory, we do your search. If turns out that, hey, you got a problem, you can't have it, then there's 100% money back guarantee. You can take your money back, and that's it. Pretend the conversation never happened, right? You get a free search, free opinion as to why we don't think your brand is trademarkable. So if you haven't done it already, again, book a call with a strategy advisor and get started. We'll do the search and take it from there. Okay, question from Sharonda Talley. It's also funny, like with all the names, I'm just I'm being so self-conscious of how many names I've probably butchered today. I'm hoping not too many. So to those whose names I messed up, I'm sorry. So the question from Sharonda is, do you need an LLC to have a trademark? Do you have an LLC? Do you need an LLC if you have a trademark? So it's two completely separate things. Trademarks help you protect your brand, right? You can own your brand through a trademark as an individual, as an LLC, as a C corp, as an S corp, like as an entity, right? It doesn't matter. A trademark is a trademark, regardless of who owns it. An LLC, you have it for liability reasons, for personal liability reasons mostly, for tax reasons, right? So there is very little overlap, if any. The name may be the same, but the purpose of getting an LLC and getting a trademark are completely separate. So you can get a trademark if you have an LLC, if you don't have an LLC, and you should have your brand trademarked if the brand is if you think the brand is worth something or will be worth something. You can have a trademark and have an LLC or not have an LLC, depending on whether that suits your business purposes, right? You might start as an individual, file a trademark, and then a year or two down the road, you realize, hey, this thing is growing. This is actually going somewhere. I'm glad I got my trademark. But now I don't want to face all this liability as an individual. I don't want them to go after my personal assets. Why don't I start an LLC, or why don't I start a corporation? And then what you can do, it's really easy, straightforward procedure that costs next to nothing, is you take your trademark registration or application, depending on how far into the process you will be at the time, and you assign that application and registration to your company, to your LLC or to your corp, depending again on the type of the entity that you start, and that's it. So for people who say, well, should I wait for my LLC? Sure. No. If you have a brand that you feel is worth something, get a trademark, file it in your personal name, file it in your dog's name. Doesn't matter. Well, that may be a bit of a stretch, but don't wait with all the tax numbers, EINs and all of us. You can start as an individual, then you can move it to your company. I hope that answers the question. Okay, here's the question from April Spring. How long does a trademark last? Where'd you get all those people, guys? Like we're getting one question that's better than the other. Thanks for asking, April. So a trademark can last in theory forever. It's the only type of intellectual property that if you renew it every 10 years, you can own it forever. Remember, I mentioned Coca-Cola's trademark filed in 1892. They're still renewing that same trademark, and I don't expect them to go anywhere anytime soon, right? So with trademarks, you file it, you get it registered, you get a registration for 10 years, and then just before it expires 10 years from registration, you got to renew it, and you get another 10 years, and then you renew it then, and you get another 10 years. And renewal costs you just a few $100s, right? That's a very simple process. You just pay a little bit of government fee. In the US, you show them, hey, we're still around. You show them evidence that you're still around, and it gets renewed and renewed and renewed and renewed. There's no examination. You don't have to prove anything to anybody. You just say, hey, I'm still there. And The only additional thing that I should mention, which also lots of entrepreneurs don't know about, who file trademarks on their own, is that in the U.S. you also have to file what's called a maintenance filing between the 5th and 6th anniversary of your trademark. So between 5th and 6th anniversary, you got to tell them, hey, I'm still here, and also show the evidence that you're still there, pay the government fee, and then take it to the 10-year mark, and then 20, 30, 50, 60, and so on, right? So trademark will outlast your patents by a lot. Trademarks will outlast your copyrights. Trademarks will outlast everything. And in fact, speaking of outlasting patents, think of pharmaceuticals, right? So that's how you get generic drugs, because Big Pharma, what they do is they come up with a new drug, and they get a patent on it because it's a new formula, and they get a very short time when they get a monopoly on that, right? So if I remember correctly, it's 20 years from the filing date, and if you think that the patent takes 5-6 years to get, then you get effectively about 14 years of protection. And so, and you can't extend that. Once it's gone, it's gone. And so they have this short period when they can stop everyone else in the country where you get a patent from selling medicine, the drugs, with that same formula. And when they file for a patent, they have to actually disclose the formula. They have to tell the world, this is what you do. You take this substance in this quantity, and you add this, and you add this, and you add that, and you get this, and here's the benefit that it provides, right? So it's public information, and so you exchange, you sharing that with the world. You give it to the world, and in exchange you get time-limited monopoly, right? That's kind of the deal with patents. And so after your patent expires, anybody can go out there and make the exact same pill, the exact same blue pill or whatever pill, with the exact same formula, the exact everything. The only thing they can't do is they can't sell that under the trademark of the original drug. So if you trademark the name, they can't use the name. If you trademark the color, which sometimes you can, they can't use the color. If you trademark the shape, if it's an unusual shape, right, you can't trademark that. And so generics, they are the same formula, they are the same thing, but they can't they can't use stuff that's still trademarked. And as I mentioned, those trademarks can last forever as long as the original company still make them. So I hope that answers that question. Okay, question from Ina Will. What's the likelihood from your experience of your trademark getting canceled after you filed because someone had the name first but refused to trademark it, but it was filed and registered? It's very, 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 very low. Because they would have to prove that you knowingly, that you knew them, that you knew that you were not entitled to file your trademark, and that you stole it from them. It's really freaking hard to prove, because you have to prove intent. And just because you were around before, you came up with a name, you had a website that nobody visited, right? Somebody else filed a trademark first, they got it. Yeah, almost impossible. I would say you might be successful with cancellation if you can prove that they provided false evidence of use. You can cancel it if you prove that they had no intention of actually using the mark, selling the products or services. If they never sold products or services under that brand, that you can. But based on just the fact that there was somebody out there prior, yeah, almost zero. Almost zero. Okay, there's another follow-up from Ina Will. Would only common law rights take place from them being... Yeah, so, exactly. So, common law rights they might still have, but the beauty of registration is that trademark registration is federal, right? So if they have common law rights, they are limited to the geographical area where they had been known under that brand on the date when you filed your trademark application. And so however big that area is how big it's going to stay. So they can carve out a small chunk out of your registration. Basically, you can't sue them for them continuing to use their own brand in that territory because they were there first. But that's pretty much it. They can't go after you. They can't. You can go after anyone else. And so again, unless they can prove that you that you infringed on their stuff, unless they can prove that you knowingly did that, it's very, 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 very difficult. And again, this is more a question to a litigator, which I'm not. But the way I see it is this: if you knowingly try to rip off someone who has a brand, you're not a good person. And if we find out that you're trying to do that, we don't want you as our client. Because again, our mission as Trademark Factory is to help growth-minded entrepreneurs build amazing brands. And the only way you do that is by getting a trademark, right? But if your goal is to knowingly rip off someone who's trying to build a brand for themselves, that, it's not something that I want to have any part of. If it so happens that you filed your trademark, you got registered, and then you realized that, hey, there was somebody out there who was doing this for some time before you filed your trademark, well, that's a different story. That basically just says that they didn't do what they were supposed to do, that they didn't believe in their brand, they didn't want to do what you should do with your brand. And so that to me is perfectly ethical for us to say, you know what, you didn't know, you did what you were supposed to do, you checked, you got your trademark. Too bad, so sad. And if they want to do something about it, right, there may be some conversation, there may be some legal, back and forth, but it would be very limited as long as they're, relatively small. So I hope that answers that question. Question from Diva CEOs. I have a sound trademark. That's rare. That's very rare. So sound trademarks, for context to those watching, is not the name, not the logo, not the phrase. It's not the color. It's the sound, right? It's distinctive sound that helps people recognize your products and services. Yeah, by the way, I'm losing my voice, so we'll probably, this is gonna be the last question, and we can, schedule another one sometime soon, and again, if you have more questions, we can, you're always welcome to book a call with our strategy advisors, and they'll answer your specific question. I'm still gonna answer, the US question here. So, sound trademarks. One of the most famous one is probably the roaring line for MGM, right? Soon as you hear it in the background, you know it's the movie and you know who it's from, right? There's let's get ready to rumble trademark, right? That's trademarked as a sound trademark. There's a few of them. So Diva CEOs have a sound trademark, which happens to be the sound of a name. Can someone else trademark the actual name as a word trademark? Okay, so I'm going to answer that question first. Actually, no. Let me read the second part because I think that's going to affect the answer to the first one. I registered the word trademark. Well, I guess you didn't register. You filed for the word trademark as well 3 weeks after somebody else, and they were aware of your trademark. Can I oppose under bad faith? So, all right. I'm glad it's going to be the last question because there's so much to unpack here. Opposing. So oppositions is what we call an atomic bomb that almost never goes off. It's about 1% of trademark applications get opposed. So to your specific question, if their trademark is still pending, hasn't been allowed, then yes, you absolutely should oppose their brand. Absolutely should oppose their trademark, and you should oppose it based on you owning the sound trademark. Oppositions will only happen after the trademarks office says yes to their trademark, right? After they approve their trademark application. And if they file their trademark for the name with respect to the same or similar products and services as yours, chances are the USPTO examiner will find that. Because when you have your sound trademark has a description that says what the sound represents. So your trademark should say something like a sound of these words being spoken out loud, right? And when they do the search, they also do a comprehensive search. They should be able to find it, and they should be able to cite your trademark application against theirs. If they cite your application against theirs and their trademark doesn't get approved, then you don't even need to bother with oppositions because that will be the end of the analysis, right? They'll have to try to respond to the office action, they'll probably fail, and so on. Only if the examiner lets their trademark through, only then would you have to oppose. And I strongly recommend that you use monitoring services, something that sends you an update as soon as the status of that other trademark changes, right? So if right now it says awaiting examination, right? You want a service that will ding you the second the status changes on the USPTO's website to either office action or approved by examining attorney and things like that. Because once it gets approved, you want to start watching as a hawk for when the opposition period opens so that you can raise your hand, file the opposition, and go after them. And so, again, for everyone, opposition is when a trademark that gets approved, the trademarks office will open a short period of time, usually a month or two, depending on the country, when anybody can raise their hand and say, regardless of the trademarks office thinking that this trademark is good to go, I am requesting that the Trademarks Office does not allow this trademark, does not register this trademark, because doing so will negatively affect my rights, and here's why, right? And sometimes it's just limited to you filing the opposition and the other party going away. Sometimes it becomes full-blown proceedings, almost like a lawsuit within the Trademarks Office system, with evidence, with depositions, with all sorts of wonderful stuff that litigation lawyers love to do. To answer this specific question, first of all, that's a great lesson, right? Sound trademarks are fun. It's a valuable brand. I'm not saying you shouldn't have done that, but I think you learned this lesson better than anyone else, that what you should have done is filed both the name and the sound at the same time. That would have made your life as an entrepreneur so much easier, because you wouldn't have to worry about those other schmucks who are trying to, take advantage of your brand. So that's lesson number one. Lesson number two is make sure that you monitor the status of that other trademark, just to make sure that once the opposition window opens, you oppose. And I certainly think that you should. I think you would have decent chances based if both trademarks are filed with respect to the same or similar products and services. So that's really all I have to answer for this question. And I don't know, do we have any last remarks? Is anything else we want to do, guys? Or we're going to be wrapping this up? Zeke? Andres? How are we doing?
I think we're all set.
Yeah.
All right. Well, thanks everyone who stuck with me for this live. And again, I think it's a great opportunity for me to answer your questions. And we'll be doing more of these. I don't know if we're going to do another one no, we're not going to do another one in October, but we're going to do another one in November. We're going to post the date, we're going to announce it, and you don't have to wait. You don't have to wait for that live. If you have a brand that you want to protect, if you're thinking about, hey, is this something that I need to protect? Is this something that I need to trademark? Go to trademarkfactory.com, click a button that says book a call, and get to talk with our strategy advisors. If you're an existing client, then you have your client cabinet. You can use the legal chat, just post something there, and you get somebody who's going to get back to you right away. And with legal chat, kind of opening you a little backdoor secret of Trademark Factory, there's a lot more people than just the legal team who see those messages. The legal team sees them, the strategy advisor see them, I see them. So if we see that here's a question from a client that has nothing to do with the legal stuff of their particular trademark, we'll find the right people to respond to you, to get back to you. So whether it's about starting a different brand, whether it's about any client experience issues, like anything really, just use that. That's the beauty of you having direct access to that function. So so I know that we had some questions from existing clients who wanted to follow up. So I asked the team to reach out to you already. Hopefully that's going to get done soon. And if you're not yet a client of Trademark Factory and you have a brand that you want to protect, well, what are you waiting for? Seriously, there's no offer on the market that's better than what we can do for you, right? We start seeing that some copycats are starting to pop up. Who are saying, yeah, we're also going to do the guarantee, we're also going to do the office actions, but it's great because I've always said there will be a day when we can't say that we're the only ones. We'll always be able to say that we were the first and we've done this for 10 years. And the stuff that we learned in the first 10 years is something that all those new copycats will still have to figure out. By the time they do, we'll think of something way, way cooler, and we're already thinking of stuff that's going to make the client experience much better than it is today. And I'm very proud of what we have now. So again, if you have a brand that you want to protect, if you're a business owner that for whatever reason you came up with a name or logo or tagline or something, and that you didn't want to call yourself some generic name, hey, we sell accounting services, right? We have a name for it. There's a reason you came up with that name. Probably the reason is you want that name to mean something. You want to be proud of that name one day. You want to have people saying, we love this brand more than anything out there in the other industries. You want people to fanatically follow your brand. In your dream, you may be very small. This could be very far from where you are right now, but there's a reason you came up with that brand. And if you believe that you have a chance of getting somewhere with it, you gotta protect your brand. And we're the team who's going to be thrilled to talk to you and see if we can help you. So go to trademarkfactory.com, fill out the form, talk to a strategy advisor. We'll take it from there. And I'll see you in the next video.